Okay, today we're going to go over the exclusive leasing and management agreement. This is the one from Georgia, but the one in Florida is pretty similar, just some slight difference on the pricing. But the pricing isn't the important part. What we want to go over is what all of the language means. This is the standard version we're looking at here. There's also the investor package, and we'll take a look at that when we get to the differences in those. There's only a few differences. But to start off with, you'll see our logo and the name of the agreement. You'll see our name and your name. Right here is the owner's name, in this case, CGR Properties. And then our name is the brokerage. The address of the property that we'll be managing, along with a legal description. So just make sure that the address matches. You probably won't know the legal description, but if you do, you can check that also. It'll show the term of the contract, which is the term of the lease that you're asking us to enter into. By default, it says 12 to 24 months, and then it'll have a minimum rent amount listed that you're authorizing us to lease the property for. And finally, it will have the date when the property can actually be occupied by a tenant. The term of this agreement, as opposed to the lease, is all discussed here. First, it has the one-year term. All of our management agreements are for an initial one-year term, and it'll have the dates here for those. If it's leased during that term, obviously the agreement will extend to cover the term of the lease, because if we have a tenant that we've placed, we obviously want to keep managing while that tenant is in there. We don't want to change management in the middle of that lease or terminate management, which can be difficult for both the tenant and the owner. We have a automatic renewal unless you provide notice to vacate 60 days prior to the end of a term. So if we sign a lease with a tenant, it's a one-year lease with the tenant. Basically, you would have to notify us more than 2 months prior to the end of the tenant's lease that you want them to vacate and you want to sell the property or hire a new management company or whatever the case may be. We just need that at least 2 full months notice. So make sure you give that to us. With the security deposits always stay in our trust account. That's to protect both you and the tenant, to make sure all the laws are taken care of with that security deposit. We do not allow owners to hold the deposits themselves, because we're responsible for doing the security deposit disposition when the tenant moves out. So we want to make sure that we have that money on hand to be able to do that. If we're taking over a property that you already have a tenant for, then you want to make sure that you transfer that security deposit to us right away. We need to have that on hand when we take over management, like I said, for disposition of it. And of course, if there has to be an eviction, we have to have money on hand to cover attorney's fees and court cost. So within 3 days, it says you'll get that sent to us. If management terminates, and the only reason this would happen with a tenant in place is basically if we terminate management because you have asked us to do something illegal, for example. Now, obviously, that's pretty unlikely, but it does happen on occasion. Sometimes we have owners who refuse to do a repair or something like that, and then we have to terminate management of the contract. If that happens, then the security deposit would be transferred to either a new broker that you have, which is what this talks about here. If you've hired a new broker after that management terminates, we'll transfer the deposit to them. Or if you don't hire a new broker, then that deposit would stay in our trust account and we would continue to be responsible for the deposit. There is a fee for us to continue doing that. But again, this is a pretty unusual situation. This only deals with termination of the contract mid-lease, which, like I said, would generally only happen if you've asked us to do something that we can't do, like not do a repair or discriminate against someone or something to that effect. So that's the only time the contract would generally be terminated mid-lease, and the only time this would really apply. If you do sell the property during the term of the contract, we automatically return the security deposit to the tenant upon sale. We do this to basically clean up the closing process. It's so there's not difficulties during closing trying to figure out who's getting credited, who's being debited, what's happening to the deposit. And it just creates a lot of legal conflicts when we're trying to deal with all that. So the easiest way to handle that in a sale is just the buyer has to acknowledge that he's not going to be receiving the deposit. It's just getting returned to the tenant. Obviously, you authorize us to deduct from the rent collected the money that you owe us for our commissions or for any repairs or anything to that effect. All right, compensation. This is the different area depending on whether you're signing up for a standard management agreement or a investor package, the upgraded agreement. So we'll go over those differences. Tenant procurement is 75% of one full calendar month's rent. That's basically the same for both. What's different between the contracts, this is the standard contract. It has a 50% of one full calendar month's rent. So that's the lease renewal fee. If you go over to the investor package, you'll see that the lease renewal fee is only a flat rate of $250. So that's a difference with the upgraded investor package. The other difference you'll see here is that there's a lease guarantee with the investor package that says if the tenant doesn't serve out the full term of their lease, we'll get you a new tenant without charging you a new fee. That doesn't apply to the standard agreement. So keep that in mind if you're trying to decide which contract you want to sign up with us. The management fee for the standard contract is 8.9% of the money we collect from the tenant. If you ask us to use a home warranty company, we increase that by 1% just because of the extra work and time involved in that. And there is a minimum monthly management fee of $50 while the property is occupied. We don't charge anything while the property is vacant. So that only applies while there's actually a tenant in the property, but we do have the $50 minimum just for those rare properties we manage, that are low rent. We manage a few properties that are only $300-400 a month in multifamily, so we had to put that minimum amount there just so we can cover our costs. If you look over at the upgraded investor package management agreement, you'll see commission is 10.9%. There's still the extra 1% for a home warranty company if you ask us to use them. The minimum, though, on this is $125 per month because of all the upgrades you get with the investor package. But you do also get a 1% discount for every property that you add to your management agreement. So if you have 5 properties, you can get a pretty good discount. It'll go down to a minimum amount of 6.9% or $100 per property. So, you can get a pretty good discount if you own multiple properties, and that applies if you buy more properties during the term of the contract and add them on. So that's one of the good things about the investor package. Late fees on both packages, we keep 50% of the late fee. You get the other 50% to help you offset any costs you might have with late bills that you have. If you have an existing tenant, then there's a $100 fee to onboard them. You'll see that that's not the case with the investor package, so that's a cost you can save there. But with the standard contract, there's a $100 fee for onboarding an existing tenant who's already in place in the property, and that's just to account for the extra work involved with that. If we have to get a new lease for the existing tenant, then sometimes this happens if you either don't have a signed lease or the lease there's some sort of flaw with it, legal flaw that needs to be corrected, something to that effect, and you have us get a new lease, then there's a $250 flat fee for that, and that's with both packages. You can see that over here also, same provision. Repairs, modernization, and maintenance is 10% of the invoice amount. Generally, you'll still see that even after our commission is added on to our vendor's repair bill, you still save usually about 10 or 20% over what you could get yourself, just because most of our vendors are giving us between 20 and 40% discounts on what they would normally charge people. And of course, this is also increased by the same 1% if you're asking us to work with a home warranty company. In case you're noticing, we generally don't recommend home warranty companies. They create lots of problems. They delay repairs, so that's why we have that extra 1% in that case. And this fee is the same when you look over here at the investor package contract. Sale of the property, it'll list the percentage here that we charge for that. Usually it's 5 or 6% depending on where you are, and that will be reduced if we're the only broker involved in the sale. We'll reduce that down to 3% usually. Of course, that obligation survives the expiration of the agreement. And what that's referring to is if the tenant buys the property. So obviously you can hire another broker if you'd like to manage your or to sell your property while we're managing it. But if the tenant buys it, then the commission is always owed to us because we procured the tenant. Other than that, if you just list the property for sale with another real estate broker and an outside party that we didn't bring in buys the property, then you don't have to pay us a commission. This only applies if someone that we procure buys it. Paper checks or statements. We generally are a paperless company. We like to stick to that as best we can. And we also like to do direct deposit in order to avoid having to send out paper checks. So if you decide you do not want to use direct deposit, there's an increase to the management fee of 1% to account for the extra work involved with that. If we have to place a stop payment on any check and issue a new one because you lost a check that we sent out, there's a $25 fee for that to just offset what the bank charges us. And that you can see is all the same in the investor package. Court appearances. This is related to, if it's related to a dispossessory action, which means an eviction of your tenant, and we did not procure that tenant, then you'll have to pay the cost of those attorney's fees and court costs. They vary depending on where your property is. Generally, this is a good range, $500 to $950. $950 is really at the high range. We don't see that too often. About an average would be about $700 to go through the entire process. And we would have to get that amount prior to us filing the eviction. We have to have that money on hand. If there's any court appearance that you ask us to appear at that's not related to just the normal dispossessory process, like if you need us to attend a bankruptcy hearing for the tenant, or you want to file a small claims suit against a tenant, something to that effect, then there's a $75 fee per court appearance for us to do that. If you look over at the investor package, this is basically the same situation. You'll see that it's basically the same language between the two of them. Owner requested inspections or trips. We normally do move-in and move-out inspections, and we also do a periodic inspection through a third-party inspection company. All they do is professional inspections. They do that once a year. If you ask us to do additional inspections, that is an additional fee. We don't generally recommend more inspections than that just because it disturbs the tenant and makes it less likely that they'll be willing to renew, which will cost you, a lot more money. Vacancies are the most expensive part about being a landlord, so you want to keep that tenant happy. Generally, a move-in, a move-out, and a yearly periodic inspection is all you really need. But if you do ask us to do another one, there is an additional fee for that, which is usually about $109, but it's depending upon where your property is and what the inspector charges for it. If you ask us to go out to the property for something unusual, for example, to pick up your mail, there's a fee for us to take care of that. And you'll see over here that this is basically the same language for the investor package. Section 8, we generally do not rent to Section 8 tenants. It's not because we have a problem with Section 8. The tenants are actually no different than any other tenants we find. The problem is the amount of work that the housing authority puts into it. They just make it very difficult, and they require us to enter into a separate contract with the housing authority that limits our ability to manage the property effectively. So we generally do not like to rent Section 8. If you specifically ask that we do that, then the fees go up because of all the additional work involved with that. So the tenant procurement fee goes up to a full month's rent, and then the management fee jumps up to 12%. And it just basically says this is to account for the higher workload involved with these Section 8 properties. We generally discourage you from doing this. It's not good for you or for us to manage these properties, Section 8, so we recommend against it, but those fees are there if you want to do that, and those are the same fees in the investor package. If you ask us to do any additional services that aren't a part of our normal management practices, then this would be the place that deals with fees for that. It's basically billed hourly. This would be for something unusual, if you want us to do consulting work on a real estate investment you're doing or something to that effect that doesn't involve the property we manage for you, then this would apply. But like I said, it's pretty unusual for this to actually be enacted, and you would be told before you were charged for anything under this, and you would have the option to choose not to. And of course, this is the same over here on the investor package. For the standard agreement, there's a $25 annual fee just for preparing the annual statements and everything associated with closing out the year. That fee is waived under the investor package, so you don't see that here on that package. Okay, now just moving on past the fees to the rest of the contract language. All of your funds will be deposited into our state registered trust account whenever a tenant makes a payment or a security deposit. It all goes into that state registered account. This just says that you give us the right to debit that account for the expenses associated with your property, such as our commissions. You are required to maintain a minimum balance in the account. This one doesn't show one, but your contract will. It's usually somewhere between $300 and $500 for a single property and goes up for multiple properties. And this is just money that you keep on hand with us to cover any expenses you have that come up while we're managing the property. So if there's for example, if a toilet breaks and we have to send a vendor out, it costs a couple $100s to fix, then we don't have to wait for you to deposit money in order to fix that. We want to have that on hand so we can take care of that quickly. Excuse me. If your balance falls below the minimum, we'll let you know about that. If you still don't deposit the money and a bill goes more than 30 days past due, there's a $75 admin fee for that. And keep in mind, the vendor is able to place a lien on your property if you haven't paid your invoice. So it's very important when we send you the email and the text message letting you know that your account is below the minimum, make sure you deposit that money right away. We also have the ability to charge 8% interest. We generally don't do that, but it's something we could do if a bill is just, it's going way too long. So hopefully that situation doesn't come up. Of course, it says we have the ability to allocate those payments towards whatever bills are outstanding. So if you only have $200 in your account and there's $400 worth of bills, it basically just says we can allocate those to the bills that we think should be paid first. We'll provide you a monthly statement and a yearly statement. Prepaid rent stays in the trust account until it is actually due. This means that if a tenant pays for a full year in advance, we sometimes see that, then that money will sit in the trust account, and as each month's rent comes due, it will be sent to you. The reason we have to do that is because technically the money still belongs to the tenant until the rent is actually due under state law. So we can't send that money to you until it's actually due. We're required to hold that in escrow. We do have to send a 1099 to every owner at the end of every year showing what your income was. So we have to make sure we have your Social Security number or tax ID on hand. Of course, you acknowledge that the banks that we do business with are always at risk of failure, just like your own bank. In the event that that your tenant bounces a payment, generally this shouldn't happen because we don't send money to you until after payments clear the bank. But occasionally a tenant will dispute a payment after that's happened, and they'll pull the money back out of the account. If that happens, you authorize us to debit your checking account to get that money back into the escrow account so that the escrow account doesn't go negative, which would be illegal under state law. You do authorize us to hold the money needed for repairs after a tenant moves out. So if a tenant has a security deposit of $1,500 and it's going towards repairs when they move out, then this just says you authorize us to hold on to that $1,500 to get those repairs done rather than sending it to you, since the repairs have to be done to get the property rent ready. Basically, this just says you authorize us to market the property for rent, place a for lease sign for rent, or for sale if you're asking us to do that also. You authorize us to put a lockbox on the property. We generally use electronic lockboxes nowadays. We'll usually replace actually your lock on your door with a smart lock, which makes it very easy to change the code at any time between tenants. It'll save you money in the long run with lock changes, and the tenants. It's much better for the tenants. They like it a lot better, and it's much easier for us to manage the property. But sometimes we will still use old-fashioned lock boxes. Either way, this just says that you authorize us to do that, and that you understand that if your personal property is still in the property while we're marketing it for rent, that you're responsible for keeping that safe, locking it up. We'll list with the multiple listing service. This basically authorizes us to do that. We generally don't list rentals in the MLS, but sometimes we will, just depending on the circumstances. Usually we syndicate them to websites instead where renters are looking for properties. The MLS is usually used more for sale properties, but this authorizes us to do that if we think it would help. Okay, the broker's authority section just goes over everything that you're giving us the authority to do with the property, which basically involves everything that could come up with managing it. So once again, it talks about advertising the property. It talks about making contracts to repair the property, to keep the property in habitable condition, which state law requires. We won't do any repairs. This has a $5,000 limit on this contract. Most of the contracts will be somewhere around $500 repair authorization. It's important to note, though, that the repair authorization limit here that you're giving us authorization to repair does not apply for emergency repairs. If a water heater breaks and it needs to be fixed, we'll go ahead and get that, because if we don't, then the tenant has no hot water and your house will get damaged. So we go ahead and do that even if it's over the maximum. And we also do that if the repair is required to maintain services to the tenant. And this is just a matter of state law. Basically, the state says that if something is broken, the landlord is required to fix it. So if the dishwasher stops working, a landlord isn't allowed to just decide, well, some properties don't come with dishwashers, so I'm not going to fix the dishwasher. The state says that if the property came with a dishwasher when the tenant rented it, then you're required to fix it. So basically what this paragraph says is, if it's a required repair, you're authorizing us to fix it. If it's not a required repair, if it's something cosmetic or something to that effect, then there's a limit that we can't spend your money above that amount. And like I said, normally this would say somewhere between $300 to $500 for most properties. If you do have a home warranty and you've asked us to use that home warranty, we will do our best to comply with that. But we do have to comply with state law, so if the warranty company is not getting the repair done in a reasonable period of time, or they're not answering their phone, or whatever the case may be, then you do give us the authorization to use one of our approved vendors. This basically just says you authorize us to hire independent contractors and employees at our company to work on your property. You authorize us to get electric, gas, etc., connected to the property if needed, to contract with others to get your property rented, to do maintenance, accounting, and so forth, to institute legal proceedings. Generally, this only involves evictions, but sometimes it can involve some other things. For example, sometimes a tenant can file bankruptcy, and we have to file a motion in court dealing with that. But generally, it's just for eviction, so you authorize us to do that. You authorize it to have the property professionally cleaned if it needs that cleaning, to have the carpets professionally cleaned, and to have the locks changed at the property between tenants and before the initial tenant, of course. This authorizes us to show the properties to show other properties to prospective tenants. Basically, it's just saying that you don't expect us to show only your property, since we manage many other properties also. You understand that we're not responsible for advising you on things that are not our specialty. So if you need an accountant, you should talk to an accountant. If you have a question about mold at your property, then you should talk to a mold expert. Those sorts of things. We're basically just saying in this paragraph that you can't expect us to be experts on everything, but we can certainly try to put you in touch with someone who is. Our specialty is real estate sales, property management, and leasing. So we can help you on those matters, but for other things that are not our specialty, you should seek out competent guidance on that. Basically, this just says the agreement is what we're all agreeing to, this written contract, and there's no other authority to act on your behalf except for what's specifically written here, so that protects you. You understand that we have to make all disclosures required by law, so you can't ask us to withhold information from a tenant that the law requires us to give them. For example, if there was a radon problem at your property, we would have to tell the tenant that. We can't keep that confidential even if you ask us to, because we're required by law to disclose that. You're giving us authority to disclose all information about the property to other people. It's basically just a marketing issue. You're allowing us to talk about the property. And of course, it has a limit on our liability of no more than our real estate commissions. The disclosures, we agree to keep your information confidential, except the stuff that we are required by law to disclose. So where this usually comes into effect is sometimes an owner will have an accountant contact us to try to get information to do their taxes. We can't give that information out until we have actually authorization from you to do that. So the big thing here is we take your privacy and your confidentiality seriously, and we won't disclose your information to third parties without your permission. We will not knowingly give anyone false information. Again, we have to be honest with everybody. If there's a conflict, not to give false information and the duty to keep your confidence, then we always have to give correct information. Basically, that just means that even though we have a duty of confidentiality to you, our duty to the public of being honest always supersedes that, and that's just the law. This just says we don't have any conflicts. If there is any conflict, we would let you know about it. For example, if we represent a tenant under a contract as a tenant agent, then we would have to let you know about that, so you would know that we're a dual agent. That's pretty rare. You don't see that happen very often. You're authorizing us to provide assistance to tenants and buyers without violating any duties to you, and you authorize us to show alternative properties to tenants, just like it said before. We basically offer all different types of agency, which means we represent buyers, sellers, landlords, and technically we offer tenant agency, but in practice we don't really represent very many tenants. But we do, in our policy manual, allow all of them. We will always disclose to you if we're representing anyone else in a transaction. Generally, the only person we'll be representing is you as the landlord in a property management relationship. But if that's not the case, if we represent someone else in the transaction, we will always let you know in writing. Same thing for designated agency, was basically just a different type of dual agency. It doesn't come up very often. You understand this is an independent contractor relationship, that we are not an employee of you. We're just a third-party service that you're hiring as an independent contractor to manage your property. Okay, this section deals with your responsibilities as the owner. So you're basically certifying that the property is in good condition, that it's habitable, and then you're in compliance with all laws. You're guaranteeing that you'll keep your insurance, landlord's insurance on the property. If you don't have landlord's insurance, if you just have a homeowner's policy, make sure you get that changed to a landlord policy before we rent it out. You'll have us named as additional insured on your policy, and you'll provide a copy of that to us within a week of starting the management agreement. Also, if you know of any environmental hazards or anything like that, you have to let us know about that. The contract says you're certifying to us that there is none of that at the property. If that's not the case, make sure you let us know. You'll keep all of your obligations on the property current. You'll pay your mortgage, your property taxes, your HOA fees, anything else that you're required to pay. This says that you're ensuring that there are no neighborhood, association, city, or other restrictions. So some HOAs have limits on the number of owners in their neighborhood who can rent out their property. If that's the case, you have to let us know so we can figure out whether you're authorized by your HOA or your city or whoever it is that has those restrictions to rent your property. Some cities even have rental licensing. So it's your responsibility to let us know if that's the case for your property, because we can't possibly know the rules for every neighborhood and every city. So, for most cities, we have a pretty good idea, but neighborhood by neighborhood, every HOA is different, so it's important for you to know what the rules are. You will not attempt to enter the property at any time while there's a tenant there. In between tenants, it's not a problem. You can go in and do your own cleanup work and that sort of thing. But while a tenant is in possession, you cannot go to the property. You have to make sure that all of that goes through us. That's to protect you as well as us. Anything you say to a tenant can be used against you. Anything you do at the property can be used against you. It is technically trespassing, even though you own the property. When a tenant is in a valid lease, they have legal possession. So if you enter the property, then you're actually trespassing. So it's important that you do not do that. It's not allowed while there's a tenant. Do not contact the tenant directly. All discussions have to come through us. Again, that is for your own protection. That's to make sure that all laws, the lease, and everything else are complied with. So do not contact the tenant directly. And we actually have penalties in the lease. If the tenant tries to contact you, we actually charge them a penalty for that in order to ensure that they don't try to contact you directly. You'll make sure that all of the utilities stay on while the property is vacant and get them reestablished after a tenant vacates. You'll give us all access codes and keys for gates and security systems, and you'll make sure to remove all of your personal property from the house. You do not want to leave anything there because technically that basically becomes the property of the tenant after you leave it there. So you don't want to be left in that situation. Some owners will try to lock stuff up in a attic or a basement or something, and then something gets stolen, and there's really no way for us to do anything about that. It's difficult to prove, so make sure all of your stuff is out of the house. If there's anything you need to disclose about the property, make sure you let us know about that. This just reiterates about emergency repairs and clarifies that any code inspector's citation is considered an emergency and has to be fixed right away. But basically, this just says you give us authority to get any emergency situation taken care of right away, and that you'll be sure to pay for those repairs within 3 days of notice. This just says that you aren't aware of any flooding at the property. If you do know of any flooding, be sure to let us know. The credit report that we get from the tenant and all the application information we receive from them is confidential. We cannot share that. We actually are required to keep that under lock and key at our office or under password protection, so we aren't able to share that with anybody. This just refers to assignment. Just means that, if our company were to merge with another company or something to that effect, that your agreement transfers to the new company. If your house was built prior to 1978, please let us know if there's any lead paint that you're aware of at the house. This says that you're not aware of any, so if that's not the case, be sure to let us know. Time is of the essence. That just means you need to sign the agreement as quickly as possible. Terminology, singular means plural. The gender pronouns aren't intended to be specific, and so on and so forth. You agree to indemnify us. Basically, that means if your tenant sues us, then you understand that you're responsible for the legal fees to defend against that, since it's your property. And the reason, of course, that anybody would be suing us would be because of the fact that you're renting the property out. So this just means that you indemnify us against that. It's a pretty rare circumstance where a tenant sues a landlord or us, but it does happen on occasion. So it's important to understand that if that happens, you do have to pay to defend against that. You understand that we cannot discriminate against anyone. We follow all fair housing laws. If you tell us to discriminate against anyone or say anything racist or anything to that effect to us, the contract will terminate. You'll owe us the commissions that you would have owed us for the entire agreement, and that'll be the end of that. We simply won't. We can't do business with anybody who wants us to discriminate against people. So we have zero tolerance on that. That is the law. Consistent policies just means that we have to maintain consistent policies across all of our leases. We can't have special rules for certain tenants that are different than rules for other tenants. So you can't ask us to not file eviction on your tenant because you feel sorry for them when we're filing evictions against other tenants, for example, or to not charge a late fee or whatever the case may be. We have to treat all tenants the same. So we have to be. Basically, this just says that you give us authority to keep our normal policies and procedures, and that you don't expect us to deviate from those. No imputed knowledge just means that we only have actual knowledge. If you don't tell us about something, then we can't possibly know about it. So if there's anything about your property that we should know, it's important that you tell us that. This paragraph's governing law will either say Georgia or Florida, whatever state you're in. In this case, this is a Georgia contract. Entire agreement just means that there are no verbal agreements. Everything in this contract is the only agreement we've made, so if any of it is incorrect, be sure to let us know about that before you sign it. You agree to cooperate with us managing the property. In other words, you won't try to interfere. You won't try to change the door locks or anything like that. Exhibits and addenda just means if anything is attached to this, such as we'll go over an attachment here in a second that deals with optional programs. This just says that those are included in this contract. This just says communication is time sensitive. You'll be sure to stay in contact with us. Notices need to be in writing regarding this contract or anything related to it. There's a new information form at the end of this contract that you'll fill out. It's important that you fill out all the information on that so we have your contact information. We are required to file a 1099 as we mentioned earlier, so you have to fill out on your new owner information form your Social Security number or tax ID so we can do that. We have a right to terminate the agreement if you try to get us to do anything illegal. This is what I discussed earlier. If you tell us to discriminate against someone or to not do a repair that's required by law or anything like that, anything that jeopardizes a tenant's safety, anything of that sort, then this just says we will terminate the contract if that happens, and you'll still owe the commissions. So obviously this won't apply to most people. Most people aren't going to try to do something illegal, but it does unfortunately come up time to time. We have one or two a year, who try to do something like this, who tell us, to discriminate against someone or something to that effect, and we have to terminate the contract. So hopefully that won't be the case with you, but this paragraph is just there to account for that kind of unusual situation. Mutual non-disparagement just says that basically if we have a dispute amongst between the two of us, that you agree to try to resolve that between us and not try to go online, anything like that to try to resolve the dispute. It should all be handled between us, as professionals, and not a situation that's out there in public trying to demean each other or anything like that. So mutual non-disparagement means we won't say anything bad about you in public, you won't say anything bad about us, and we'll just try to resolve things professionally. Waiver of jury trial speaks for itself, and that goes for both sides. We can't sue you and request a jury trial. You can't sue us and request a jury trial. It's just to keep costs down if there is some sort of dispute. And if there is a dispute and there is attorney's fees or court costs, then whoever wins is the person who pays those. So obviously these provisions here and the mutual non-disparagement don't really apply to the vast majority of people. This is just if there is some sort of a dispute, and usually this revolves around what we talked about previously with termination for cause. These sort of things usually only come up if someone is trying to get us to do something illegal. So if someone is trying to get us to not do a repair that the law requires, usually they will tell us not to do that repair. We will cancel the management agreement. Then they'll get mad. They'll go online and say something about us that's libelous. Then we'll file a lawsuit against them for doing that. And then there's attorney's fees and court costs. So those things are all, all these things here are usually related, which means they're not very common. Usually it only happens when an owner is trying to break the law. But if those situations come up, then all of this stuff says how it will all work, and basically it's designed to make it all go as smoothly as possible, and for the party who was actually in the right not to have to suffer. So, if you were in the right and you told us to do something and we said we wouldn't, and a judge determined that you were right to tell us that, then you would be entitled to have us pay your attorney's fees, no jury trial to make it go nice and quick, and we couldn't say anything bad about you. But of course the same is also true. If you tell us to do something illegal, we refuse to do it, we file a lawsuit, and the judge rules in our favor, the same is true for us. So basically this is here to keep everybody honest and everybody abiding by the contract. So it usually doesn't come up because most people that we work with are pretty honest. So not usually an issue. With special stipulations, this would just be if there was anything unusual about your property that we needed to put in here. For example, if your property has utilities that have to stay in your name and can't be in the tenant's name, you might list something here about that. If there is something special that you need included here, just be sure to let us know about that. And then, of course, we just have the signature page. You'll sign here. We'll sign down here. And then our brokerage's information is just listed here. These are our MLS and state ID numbers. Then we get down to the premium options. Now, this is different with the two contracts. So if you go over to the investor package agreement, you'll see it's a lot shorter because a lot of this stuff is included already. So there's more options on the standard package. So twice yearly interior inspections is something you can sign up for. That's true for both packages. Standard is 1 year, but you can always sign up for extras. You just have to let us know that. Check off this box and we will do an extra one. The lease guarantee program, this is standard, so it's not on the investor package agreement. But if you want to sign up for that under the standard agreement, you can sign up for that, and there's just a $100 fee for that at initial lease signing. Professional photos, again, this is standard with the investor package, but on the standard package, there's a $200 fee for that. For a 3D virtual tour, again, standard with the investor package, but $275 with the standard package. And this is if you've ever seen one of these, it's very nice. Basically, someone can walk through your house, seeing it as it really is in 3D. If they have a 3D headset like an Oculus, it's like they're actually there. So it's an incredible piece of technology, and we have a partner partner company that goes out and does those 3D photos and professional photos. So you can sign up for these on the standard package or on the investor package. Those are standard; they come with it. Property damage protection. Basically, this protects you from a tenant damaging your property. So if a tenant moves out and they've left, $1,000 in damage, you can basically have us pay for that damage if you pay for the damage protection program. And the fees are here at different protection amounts. Basically, this money just goes into our account to allow us to pool money from all the different owners for when these repairs come up. So if that's something that interests you, you can sign up for that. Just check the box next to the one you want, and we'll get you signed up for that. And that is the same for the investor package. That's always an optional program. It's not something you have to sign up for. Eviction protection. This basically covers the cost of an eviction for both attorney's fees, court costs, and the eviction crew and locksmith. Usually these total up to about $1,200 all in. You can actually get us to cover that without any risk to you at $15 a month. You pay that, and then we will cover all of these costs if your tenant does have to be evicted. No cost to you. And that's the same on both contracts. The rent collection guarantee program. This is a really unique program we offer. Basically, this program says if your tenant doesn't pay the rent by 10 days after it's due, then we'll pay it to you out of our own pocket. So the cost of the program depends on what your monthly rent is. Up to $1,600, which is most of our leases. It's only $29 a month, or you can get a discount and pay $290 a year. If your property is a little more expensive, it can be $43 a month, $430 a year. And this basically gives you protection for up to 4 months. So if we have to evict your tenant, this will make sure that while we're doing that eviction process, you're continuing to get your monthly rent. So again, this is an optional program. It's optional under both packages. You don't have to sign up for it, but if you're interested, just check the box out here, and we will send you a contract to sign up for that. Okay, last thing is the new owner information form. This is basically just where you fill in all of your contact information, your direct deposit information, your social security number or tax ID for the 1099. If you have a home warranty, this is where you put that information. If you have vendors that you already have that you prefer to work on your property, you can list those here. They do have to be fully licensed and insured. They have to have workers' comp and general liability. But if they do have that, we're happy to use any reputable vendor you have. Otherwise, we'll use our standard vendors. And we do recommend our vendors because you'll probably get better pricing, but it is up to you. And then, of course, there's information here you can fill out for your utility company, garbage company, and so on. The important things here, we'd like for you to fill it all out, but if you don't have some of the information, we understand. But the HOA is the important thing. We want to have the HOA information. If you have an HOA in your neighborhood, just so we're able to contact them and know what the yearly dues are if the tenant wants to access the amenities in the neighborhood, we charge them for that. So this is very important information for us to have. Finally, you'll see an ACH authorization. Basically, this just says that you authorize us to take the portfolio minimum out of your bank account as soon as you sign the contract so that we can get to work on starting to manage your property. That's about it. If you have any questions about the contract, just send us an email at support@gtlrealestate.com or speak to your leasing agent who you've been speaking to about our services, and we'll be happy to get those questions answered.